Your medical bills are $47,000. You haven't worked in 3 months. The insurance adjuster calls you on a Tuesday and offers you $18,000 and says, "You've got 72 hours to decide." Your spouse says you should take the money. You know you need it. You call back on Wednesday and you accept. 2 weeks later, a spine specialist finds that you've got a herniated disc and you need surgery. It's going to cost you $80,000. You call the adjuster back. She says, "Sorry, you've already settled." That 17-minute phone call cost you everything, because that first offer is designed to close your case before it's fully worth anything. In Illinois, most car accident settlements move through 5 distinct stages where leverage shifts and your claim value can grow. Hi, I'm Illinois injury attorney Jason Marker, and I've settled hundreds of car accident cases here in Illinois. Before you settle, you need to know exactly how this all works. 1. The settlement process starts before you think it does. Maria was rear-ended in Naperville at a stoplight and didn't call a lawyer for 3 weeks because she was waiting to see how bad it was. By week 4, she got $22,000 in medical bills. The other driver's insurance had a recorded statement taken from her where she said, "I'm fine." And on day 2, the adjuster is now arguing that the injuries aren't related to the crash. The car accident settlement process in Illinois actually begins the moment of your accident, not when you decide to file a claim. And every action that you take before the formal negotiation starts affects what you'll eventually receive. Here's what's actually happening in those first 30 to 90 days. You're treating with doctors and you're accumulating medical records. The insurance company is investigating. They're investigating liability, they're pulling police reports, they're reviewing your social media to find anything that contradicts your injury claims. They're calculating what they think your claim is worth using their internal software. And believe me, they have those. And they're coming up with a number that they think is lower than your claim is actually worth. If you give a recorded statement too early, the value drops. Settlement before MMI, the value collapses. Post the wrong picture on social media, you've handed them a lot of ammunition. Maximum medical improvement is the key timeline marker. That's when your doctor says that you're as healed as you're going to get. In Illinois, most car accident claims shouldn't enter any serious settlement negotiation until you've reached MMI, because until that point, nobody knows the full extent of your damages, not even you. A back strain that seems minor at week 2 can become a herniated disc, requiring surgery later at week 12. If you settle at week 2, you've just funded your own surgery out of that small settlement you received. The settlement timeline doesn't start when the insurance company makes an offer. Rather, it starts when you have a complete picture of your damages, and that typically takes 3 to 6 months minimum after most accidents. The insurance company's entire strategy is to get you to shortcut that process before you understand what your case is actually worth. Robert's attorney sends a 3-page demand letter with no medical records. The insurance company, responding with a $15,000 offer on the claim that is actually worth $150,000. Robert's confused. Why so low? Well, because in the car accident settlement process, your demand package is your opening argument. And if it's weak, the insurance company knows that you don't understand the value of your case or that you won't fight for it. The demand isn't just asking for money, it's proving why you deserve it and setting the entire negotiation rate range. A proper demand package in Illinois includes your demand letter, all medical records and bills, wage loss documentation, police reports, photos of vehicle damage and your injuries, witness statements, and expert reports if needed. The demand letter itself tells your story. How the accident happened, why the other driver is 100% at fault, every injury that you sustained, every treatment that you received, and how those injuries changed your daily life, and a specific dollar amount that you're demanding. This is the first time that an insurance company sees everything in one place, and their response tells you whether you're in a real negotiation or some lowball game. Here's what most people don't understand about demand numbers. Your demand should give you room to move and negotiate, staying credible based on the records, high enough to leave room to come down, but grounded enough that the insurance company takes it seriously. If your damages are $75,000 and you demand $250,000, they know you're not serious. If your demand is $85,000, you've left no room to move. The insurance company typically responds within 30 to 45 days. They respond with a counteroffer that's significantly lower than your demand. And that's where the negotiation actually begins. Negotiation is a back and forth dance with specific rules. Sandra receives a $35,000 counteroffer on her $120,000 demand. She's insulted and tells the adjuster the offer is ridiculous. The adjuster says, "Okay, well, let me know if you change your mind," and stops calling. 2 months pass and Sandra panics and calls back, accepting the $35,000 offer. The adjuster says, actually, we've reconsidered. Our offer is now only $28,000. Sandra just learned that negotiation has rules, and walking away without a countermove means you lose leverage. The negotiation phase typically involves 3 to 5 rounds of offers and counteroffers, which can last anywhere from 60 to 90 days. An insurance company offers $35,000 on your $125,000 demand. You counter at $95,000 with additional medical documentation showing why their offer doesn't cover your damages. They then come back at $55,000. You counter at $80,000. They counter back at $65,000, and you all reach $72,000 as a middle settlement range. Each round of back and forth, the side moves towards the middle ground, and it requires continued justification for your number. You explain why the medical bills support it, why the wage loss requires it, why the permanency of your injury demands it. This is where Illinois law can cut your settlement significantly. If you're found 51% or more at fault for your accident, you recover nothing. So if there's any dispute about who caused the crash, the insurance company uses that as leverage to reduce their offer, arguing that your percentage of responsibility should come directly off of the settlement value. Even 20% at fault means 20% less money for you. This is why the liability investigation in stage 1 matters. Solid proof that the other driver was 100% at fault removes that negotiation weapon entirely. The back and forth continues until you reach an agreement or until negotiation stalls, which leads us to stage 4, mediation and litigation. Thomas and the insurance company are stuck. They've been negotiating for 4 months. The company won't go above $88,000. Thomas won't go below $110,000. Nobody's moving. Then Thomas' attorney files a lawsuit and schedules mediation. Suddenly, the adjuster calls. Hey, we can do $105,000 to avoid litigation costs. Surprise, the case settles 3 weeks later. Thomas just experienced what happens when settlement negotiation reaches a leverage shift, the point where the insurance company's costs of defending a lawsuit exceed the cost of meeting your number. Mediation is a formal settlement conference with a neutral third-party mediator. Typically, it's a retired judge or an experienced attorney who helps both sides try to reach an agreement. In Illinois, many car accident cases go to mediation before trial, and the session usually lasts about 4 to 8 hours with both sides in separate rooms while the mediator shuttles back and forth. Mediation resolves the majority of cases that reach it because the trial risk becomes real and the file gets reviewed by people who can actually authorize more money. The insurance company knows that if mediation fails, they're going to trial. Attorney's fees, expert witness costs, and the risk of a jury verdict far above the settlement are a very real possibility. This is where the Illinois statute of limitations becomes critical leverage. You have 2 years from the accident date to file a lawsuit. And as the deadline approaches, your leverage increases. If you're at 20 months post-accident with no lawsuit filed, the insurance company knows that you might miss the deadline and lose everything. If you file at, say, 18 months, you've protected your claim and shown that you're serious about your trial. Once a lawsuit is filed, the insurance company's costs start mounting. In our experience, settlement offers commonly increase substantially compared to where they stood before litigation. Number 5, settlement payment and release ends your claim forever. Jennifer settles for $142,000. She's excited. The adjuster says the paperwork is coming. 4 weeks pass, no check. Jennifer calls. The adjuster says, we're waiting on your release signatures. 3 more weeks pass. Jennifer finally receives a settlement release. She signs it and sends it back. She gets her settlement check about 2 weeks later, 8 weeks after agreeing to settle initially. Then she discovers that the settlement was $142,000, but her check is only $94,600. Where did the rest of the money go? Medical liens, attorney's fees, case costs, she didn't fully understand. The final stage of the settlement process is where the agreement becomes payment, and it's filled with details that catch people off guard. Here's what happens after you accept a settlement offer. The insurance company drafts a settlement agreement and a release, which is a legal contract stating that you're accepting X dollars in exchange for releasing all the claims against their insured driver forever. Read this document carefully because all claims mean exactly that. Future medical complications, future wage loss, everything. You cannot reopen the case if you discover new injuries later. Once you sign, you're done. The release goes back to the insurance company. They process the payment, and a check is issued to you and your attorney jointly. The check is typically deposited by your attorney in his or her trust account. From there, liens are paid first. Medical liens are legal claims against your settlement by healthcare providers or insureds who've paid your medical bills in Illinois, such as health insurance companies. They have a legal right to reimbursement under subrogation laws in Illinois. Medical providers who treated you on a lien basis, agreeing to wait for payment until settlement, get paid also from those proceeds. Your attorney negotiates these liens down if possible, but they must be satisfied before you receive your portion. After liens, your attorneys typically take their fee, which is usually 1/3 of the total settlement. Case costs are also deducted, and then you receive the remainder. This is why a $142,000 settlement becomes $94,600. The number the insurance company offers is not the number that you take home. And that's why you always want to evaluate offers in net dollars, not headline dollars. So now you understand the settlement process, how it works from demand to check. But what happens when the driver who hit you wasn't just negligent, they were drunk, and the bar that overserved them kept pouring away even after they visibly knew he was intoxicated? In Illinois, bars and restaurants can be held liable for drunk driving accidents under the Dram Shop Act and different laws. They follow a completely different process with much higher settlement values. I break down exactly when a bar can be held responsible in my next video. When can a bar be held responsible for drunk driving accidents? Watch that next video, and if you're in a settlement negotiation right now and you need someone who knows the timeline and the leverage points, please call Marker Law. We'll fight for your claim, and we'll fight for what it's actually worth. Thanks for watching.